Hi, YouTube. Let's take a look at another case. Today we're going to look at Caniglia v. Strom. I think that's probably pronounced Caniglia, but I'm going to go with Caniglia. Caniglia v. Strom. Its citation is 141 Supreme Court 1596, decided in 2021 out of the U.S. Supreme Court. It sounds at first like it might be a Second Amendment case, but it's actually a Fourth Amendment case, which is consistent with a lot of the cases that we've been looking at. This one has to deal more with our rights with respect to our homes and the police's ability to come into our homes. So as always, let's take a look at the court that decided the case. It was a unanimous decision. Justice Thomas wrote the opinion, and if we look at the makeup of the court in the 2021 and who appointed them and what their ideological leanings are. We've got Chief Justice Roberts, who was appointed by George W. Bush, generally conservative, but he's surprised conservatives in several very important cases. So moderate to conservative, maybe swing vote, maybe more descriptive. Clarence Thomas has been a very consistent conservative the whole time he's been on the court. George H.W. Bush appointed him as the first African American appointed by a Republican. He's definitely been consistently conservative. So Stephen Breyer was actually, I think, at this point already retired or about to retire, but had been involved in the early stages of this one. He was appointed by Bill Clinton. Generally liberal on the court, maybe moderate liberal. But definitely on that side of things in general. Next is Samuel Alito, appointed by George W. Bush, very consistent conservative. Then we've got Sonia Sotomayor, appointed by Barack Obama, has been pretty consistent liberal on the court. Elena Kagan, Barack Obama appointed her. She's also been liberal. I think she's surprised maybe some liberals on a couple of cases. But I think in general, she would be considered liberal on the court. Neil Gorsuch, appointed in Donald Trump's first term, has been pretty consistent conservative. These next three are all the same thing. They're all appointed by Donald Trump. Brett Kavanaugh, Amy Coney Barrett, all generally conservative, I think people would agree, but each of them have surprised their side on a couple of big cases, I think. So it's an interesting makeup of the court, and it's an interesting decision in that it's a unanimous decision. You just don't these days see a lot of unanimous decisions. So that's the court right now. Let's go ahead and take a look at the decision. So the syllabus, basically a summary. We'll go through this whole thing. During an argument with his wife, petitioner Edward Caniglia placed a handgun on the dining room table and asked his wife to shoot him and get it over with. His wife instead left the home and spent the night at a hotel. The next morning, she was unable to reach her husband by phone, so she called the police to request a welfare check. The responding officers accompanied Caniglia's wife to the home, where they encountered Caniglia on the porch. The officers called an ambulance based on the belief that Caniglia posed a risk to himself or others. Caniglia agreed to go to the hospital for a psychiatric evaluation on the condition that the officers not confiscate his firearms. But once Caniglia left, the officers located and seized his weapons. Caniglia sued, claiming that the officers had entered his home and seized him and his firearms without a warrant, in violation of the Fourth Amendment. The district court granted summary judgment to the officers. The First Circuit affirmed, extrapolating from the court's decision in Katie, and that's a case that gets referred to quite a bit in this case, a theory that the officer's removal of Caniglia and his firearms from his home was justified by a community caretaking exception. That's what this whole case is about. Is there a community caretaking exception, and does it apply in this situation? Held, neither the holding nor logic of Katie justifies such warrantless searches and seizures in the home. They go on to say, the court noted that the officers who patrol the public highways are often called to discharge non-criminal community caretaking functions, such as responding to disabled vehicles and investigating accidents. But searches of vehicles and homes are constitutionally different. That's the kind of the core holding here. Your car and your house are two different things when it comes to Fourth Amendment analysis. The very core of the Fourth Amendment's guarantee is the right of a person to retreat into his or her home and there be free from unreasonable government intrusion. A recognition of the existence of community caretaking tasks like rendering aid to motorists in disabled vehicles is not an open-ended license to perform them anywhere. Certainly not in the home. And the conclusion is this case is vacated and remanded. And then again, Justice Thomas delivered the opinion for unanimous court. Justice Roberts filed a concurring opinion that we'll look at, and that Breyer joined. And Alito and Kavanaugh both filed concurring opinions, but I don't believe anybody else joined in those concurring opinions. So Justice Thomas delivered the opinion of the court. Decades ago, this court held the warrantless search of an impounded vehicle for an unsecured firearm did not violate the Fourth Amendment. That's a vehicle, and that's the Katie case that was referred to. The court observed that police officers who patrol the public highways are often called to discharge non-criminal community caretaking functions, such as responding to disabled vehicles or investigating accidents. The question today is whether Katie's acknowledgement of these caretaking duties creates a standalone doctrine that justifies warrantless searches and seizures in the home. It does not. That's their conclusion. During an argument with his wife, Caniglia retrieved a handgun from the bedroom, put it on the dining room table, and asked his wife to shoot him now and get it over with. She declined and left to spend the night at a hotel. The next morning, she could not reach him by telephone. She called the police to request a welfare check. So the police were also named in this case as the et al. In the style. Respondents accompanied petitioner's wife to the home, where they encountered petitioner on the porch. Petitioner Caniglia spoke with the respondents and confirmed his wife's account of the argument, but denied that he was suicidal. Respondents, however, thought that petitioner posed a risk to himself or others. They called an ambulance, and petitioner agreed to go to the hospital for a psychiatric evaluation, but only after respondents allegedly promised not to confiscate his firearms. Once the ambulance had taken petitioner away, however, respondents seized the weapons, guided by petitioner's wife, whom they allegedly misinformed about his wishes. Respondents entered the home and took two handguns. The police misinforming and misstating things is something that it's its own separate issue. Petitioner sued, claiming that respondents violated the Fourth Amendment when they entered his home and seized him and his firearms without a warrant. The district court granted summary judgment to respondents, and the First Circuit affirmed solely on the ground that the decision to remove petitioner and his firearms from the premises fell within a community caretaking exception to the warrant requirement. And so they're saying that, yeah, Katie does apply. The rules with respect to the community caretaking exception dealing with cars is the same for houses, and they say Caniglia loses. That's what was found in the First Circuit. So Thomas goes on to say the Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The very core of this guarantee is the right of a man to retreat into his own home and there be free from unreasonable government intrusion. The Fourth Amendment does not prohibit all unwelcome intrusions, only unreasonable ones. And then they go to talk about exigent circumstances and someone destroying evidence and that type of thing. The First Circuit's community caretaking rule, however, goes beyond anything this court has recognized. Neither the holding nor logic of Katie justifies that approach. True, Katie also involved a warrantless search for a firearm, but the location of that search was an impounded vehicle, not a home. That's the case. A constitutional difference that the opinion repeatedly stressed. Katie expressly contrasted its treatment of a vehicle already under police control with a search of a car parked adjacent to the dwelling place of the owner. Thomas goes on to say what is reasonable for vehicles is different from what is reasonable for homes. Katie acknowledged as much, and as this court has repeatedly declined to expand the scope of exceptions to the warrant requirement to permit warrantless entry into the home, we thus vacate the judgment below and remand further proceedings consistent with this opinion. So pretty short opinion, to the point. Katie does not apply to homes. They had no right to do a warrantless entry into that home. And so that's the case. That's the unanimous decision. That's the whole case. Then just because a couple of these justices did not want things to be misunderstood, that they didn't want the meaning of this case to be broader than what they intended, they wrote concurring opinions. Now, being a unanimous decision, and none of these concurring opinions has more than two people signing off on it, I don't believe that anything that's said here would affect how the case would be interpreted in future cases. But so let's look at Justice Roberts' concurrence, which was joined by Breyer. He says, 15 years ago, this court unanimously recognized that the role of a peace officer includes preventing violence and restoring order, not simply rendering first aid to casualties. A warrant to enter a home is not required, we explained, when there is a need to assist persons who are seriously injured or threatened with such injury. Nothing in today's opinion is to the contrary. I join it on that basis. So he's saying he agrees with the opinion, but if there's someone actually that's seriously injured or threatened with such injury, and to me that's exigent circumstances, but that's what he's saying, that he wants to make sure it's clear. We're not saying the police can't go in that situation, and that's his view of it. Justice Alito wrote a concurring opinion also. He says, I join the opinion of the court, but write separately to explain my understanding of the court's holding and to highlight some important questions the court does not decide. He says, the court holds, and I entirely agree, that there is no special Fourth Amendment rule for a broad category of cases involving community caretaking. We should not assume that the Fourth Amendment's command of reasonableness applies in the same way to everything that might be viewed as falling into this broad category. It says, while there is no overarching community caretaking doctrine, it does not follow that all searches and seizures conducted for non-law enforcement purposes must be analyzed under precisely the same Fourth Amendment rules developed in criminal cases. Those rules may or may not be appropriate for use in various non-criminal law enforcement contexts. We do not decide that issue today. He's not saying what the rule is one way or the other. He's just saying that's an open question in his view. This case falls within one important category of cases that could be viewed as involving community caretaking, conducting a search or seizure for the purpose of preventing a person from committing suicide. Assuming that petitioner did not voluntarily consent to go with the officers for a psychological assessment, he was seized and thus subjected to a serious deprivation of liberty. But was this warrantless seizure reasonable? He goes on to state that every state has laws allowing emergency seizures for psychiatric treatment, observation, or stabilization. But these laws vary in many respects, including the categories of persons who may request the emergency action, the reasons that can justify the action, the necessity of a judicial proceeding, and the nature of the proceeding. Mentioning these laws only in passing, petitioner asks us to render a decision that could call features of these laws into question. The court appropriately refrains from doing so. So they're not going so far as to say that you can't enter on a case where there's some possibility someone may be suicidal. This case also implicates another body of law that petitioner glossed over, the so-called red flag laws, and I'm sure we'll see more cases on that down the road. These laws enable the police to seize guns pursuant to a court order to prevent their use for suicide or infliction of harm on innocent persons. Provisions of red flag laws may be challenged under the Fourth Amendment, and those cases may come before us, and I think they will. Our decision today does not address those issues. Again, he's basically making the argument of don't read too much into this case. These things are not addressed in this case. So one additional category of cases should be noted: those involving warrantless, non-consensual searches of a home for the purpose of ascertaining whether a resident is in urgent need of medical attention and cannot summon help. And he goes through examples of what that situation may look like. Our current precedents do not address situations like this. We have held that police may enter a home without a warrant when there are exigent circumstances, and I think that would be covered by exigent circumstances. But circumstances are exigent only when there is not enough time to get a warrant. And warrants are not typically granted for the purpose of checking on a person's medical condition. So I think makes probably a fair point there. Then he goes on to say, perhaps states should institute procedures for the issuance of such warrants. But in the meantime, courts may be required to grapple with the basic Fourth Amendment question of reasonableness. Again, he's not saying this is what the rule is. He's just saying these are some things that are not in this case, some things that may come up, some things we may need to look at. The three categories of cases are simply illustrative, and other non-law enforcement purposes may arise and may present their own Fourth Amendment issues. Today's decision does not settle these questions. Okay, and then the next concurring opinion is from Justice Kavanaugh. It says, I write separately to underscore and elaborate on the Chief Justice's point that this court's decision does not prevent police officers from taking reasonable steps to assist those who are inside a home and in need of aid. Again, another concurrence that basically wants to be sure that we don't read too much into the case. It says, police officers may enter a home without a warrant in circumstances where they are reasonably trying to prevent a potential suicide or to help an elderly person who has been out of contact and may have fallen and suffered serious injury. He goes on to say, drawing on common law analogies and a common sense appraisal of what is reasonable, the court has recognized various situations where a warrant is not required. So he's saying, and again, this is overlapping with exigent circumstances. Maybe there's something that's not exactly exigent circumstances, but he's saying that he believes that it would still allow for the police to go in. And again, this is a one-person concurrence. This is not force of law in any way coming out of this case. He goes on to say that this case does not require us to explore all the contours of the exigent circumstances doctrine as applied to emergency aid situations because the officers here disclaimed reliance on that doctrine. But to avoid any confusion going forward, I think it important to briefly describe how the doctrine applies to some heartland emergency aid situations. It says the responsibility of police officers to search for missing persons, to mediate disputes, and to aid the ill or injured has never been the subject of serious debate, nor has the responsibility of police to provide services in an emergency. Consistent with that reality, the court's exigency precedents, as I read them, permit warrantless entries when police officers have an objectively reasonable basis to believe that there is a current ongoing crisis for which it is reasonable to act now. Officers do not need to show that the harm has already occurred or is mere moments away, because knowing that will often be difficult, if not impossible, in cases involving, for example, a person who is currently suicidal or an elderly person who has been out of contact and may have fallen. If someone is at risk of serious harm and it is reasonable for officers to intervene now, that is enough for the officers to enter. To be sure, courts, police departments, and police officers alike must take care that officers' actions in those cases are reasonable under the circumstances, but both of those examples and others as well, such as cases involving unattended young children inside a home, illustrate the kinds of warrantless entries that are perfectly constitutional under the exigent circumstances doctrine, in my view. With those observations, I join the court's opinion in full. And then we get into the footnotes section. Again, as always, I recommend that you read the footnotes themselves. They usually have some very substantive information in them as well. Okay, so that's the case. The main finding is we have greater Fourth Amendment protections in our homes than we do in our cars and elsewhere, and the community care exception was overreaching in this case. Caniglia touches on firearm ownership, but is really a Fourth Amendment case. Most of our time was spent on concurring opinions that tried to clarify what the case was not. I do believe we'll see more significant cases in the area of red flag laws and any number of topics falling under the Second Amendment going forward. I hope that was helpful. If you liked the video, I'd appreciate a like, and if you want to see more videos addressing U.S. constitutional law cases, please subscribe and hit the notifications button. These are, by their nature, as Supreme Court cases, pretty weighty matters, so I hope people will begin to have comments and spark some discussion. We should be back next week with another case. I do appreciate your time. Thank you.